Welcome back to the Law News Network, everybody. This is Jesse Weber. Thanks for joining us. Again, we're just showing some bit more clips right now about what's been happening in the Luis Toledo saga, as I should say, the case that's going on out of Florida. Those were the jury instructions that was given by the judge to the jury, a template for them to follow as they enter into their deliberations. As we were talking about earlier, the deliberations are going to begin quite early today, and maybe we might get a verdict today. But to help me talk a little bit about those jury instructions, I'm here with former federal prosecutor Andrew Maloney. Before we went to check out what more was happening in the courtroom, I want to get into a little bit about these jury instructions. Maybe you could help explain it a little bit for our viewers. So there's two different counts, really. There's a different charge for the killing of Yesenia Suarez versus the killing of these two children. We're talking about a difference between first-degree murder and second-degree murder. The idea that was put forward by the prosecution was that the first-degree murder charge against the children was because they were witnesses. Mr. Toledo premeditated on that and wanted to kill them. The second-degree murder charge against his wife, Yesenia Suarez, is because apparently there was some sort of fight, there was an altercation, and he karate chopped her in the throat. But as we talked about in the break, you would have gone for first degree in all of them.
Yeah, I would have gone for first degree, and the reason I say that is because I think the evidence demonstrated that Toledo knew before confronting her that she was having an affair, or at least that's what he believed was occurring. And so he went there with, I think, malice in his mind and in his heart. Now, a jury might say, well, we don't know if he went there intending to kill her. In other words, the premeditation, which you need for first degree. But they might be able to come to that conclusion that he did go there with the intent to kill her, and essentially her and any witnesses, i.e. the children. So I don't see any downside for the prosecutor charging him with first degree for the killing of his wife. A jury may or may not think that premeditation to kill her was proven, but there's evidence there that would support it. His defense, and he didn't take the stand for this, but what he told the police officers is that, we got into a fight, an altercation, I gave her a karate chop and killed her. Well, that's what he says. We don't have a body. She might have died from another means, and he's the person who allegedly destroyed or secreted the evidence by burying them or disposing the body, so that the police don't have that to determine whether or not that is exactly how she died. So he's deprived the police of that evidence. And I don't, as a juror, they might say, well, listen, if you in fact killed her with a karate chop and it was just one crime of passion that took place instantaneous, tell us where the body is, show us, and then we'll do an autopsy and find out how she died, what the cause of death was. Now, he's not obligated to do that. The Fifth Amendment says you don't have to incriminate yourself. But the defense has got some holes in it, and if I were the prosecutor, I probably would have charged him with the top count for the killing of his wife too. Now, at the end of the day, it might not matter, because if the jury is not sure on that one, but they're pretty sure on the two children, he's going to get a conviction for first-degree murder, and he's facing the death penalty for that. So really, I guess in this case, may not matter.
But as we were saying, it doesn't really matter, because these lesser includeds are part of the offense. In other words, if the jury says, you know what, if they did charge him with first-degree murder with connection with Yesenia Suarez, they said, maybe we don't quite take that, but we see it more as second-degree murder. But as we saw here, there's lesser includeds in what we actually have. So even if the jury doesn't see that this was second-degree murder against the wife, or even first-degree murder against the kids, it can be dropped down to lesser charges. And I think I just need some clarification a little bit, or maybe our viewers do as well. Can you explain the difference between, okay, this was a heat of the moment, there was adequate provocation, or this was a guy who committed these crimes because he had a depraved mind without the regard to human life? That is the second-degree murder charge. So maybe just explain a little bit more about what do these aggravated manslaughter offenses mean? How is the jury supposed to think about this, and based upon the evidence they heard and the story that was put forward by Mr. Toledo?
Yeah, look, it all boils down to his state of mind when he committed the acts. And that's the difference between first and second-degree murder and manslaughter. So if the jury believes he acted because he was angry and he premeditated the murders, that's the top count. That's first-degree murder. If they think maybe he didn't plan it, but got into a fight and was so enraged and got violent and struck her or hit her or did something that caused her death, and then he's now panicking and he's got to cover it up, then they might say, okay, second-degree murder is more appropriate. Depraved mind, during this argument, and he got violent. It's a lot harder to, I think, that defense is a lot harder when it comes to the two children. They didn't participate in the affair. They did nothing to provoke him for their murder. So I think that defense might hold some water in the death of his wife, but not the children. They're innocent, and I think that's going to be the difference maker in this case, and why the jury will probably come back with a first-degree murder conviction for the killing of the children. I think in our society, as a parent, you do everything you can to protect your children, and if you do something to harm children, your own children in particular, that's beyond any realm of an excuse or crime of passion. It does not seem to fit. So I think the jury may have a problem with that, and a problem with him in that course of conduct.
Yeah, I agree with you. I think the prosecution really nailed it clearly when they said these are the reasons, the motives that were put forward because they're witnesses and the cheating. But there's really no excuse ever to killing a child. And I think what they were trying to really put forward by the prosecution is, okay, here's Mr. Toledo. On one hand, he thought, okay, I can't get away with the killing of Yesenia Suarez. You know what? I know I'm being implicated in that, but maybe it's excusable. She was cheating on me. We got into a fight. Maybe I can get away. But there's no excuse with the children. Right. So he had to throw the blame on another individual. And I just want to briefly talk about this with you as we move into Willis, which we will be turning to any moment. I do want to ask you, the idea of this other person, this Tyshawn Jackson, there's no evidence showing there. That's why I believe this jury is going to come back with a verdict pretty soon. But it's not for me to decide, and it's not for anyone to decide but the jury. But I'm curious about your thoughts about Tyshawn
Look,
Jackson.
it's a desperate move. It's not uncommon when you have nothing else to try to point the finger at somebody else who's not in the courtroom, even when there's no evidence, because you're hoping that maybe one juror will say, well, we didn't hear much about that. I have reason to doubt. Maybe that is true. Reasonable doubt doesn't mean beyond all 100. It doesn't mean 100%. But if a defense lawyer comes up with some kind of excuse or points the finger and makes some kind of argument, even without evidence. I mean, what the attorneys say is not evidence, it's argument, and that's essentially what you heard. They're hoping that they can get one of those jurors to start to say, well, we don't know enough about that, and maybe that's reason to doubt. I mean, he's facing the death penalty. This is such a horrific crime, and I'm not sure. So that's what they try to do. It usually does not work. Unless you have some evidence, some cogent argument to put together, it usually does not stick.
I agree with you. Well, stick around because we are going to be covering that case, but also we're going to be covering Michigan v. Jeffrey Willis, which is what we're going to turn to right now. So we do have our live feed I should say our audio feed, because cameras are not allowed in the courtroom, but we do have our audio feed in the Michigan v. Jeffrey Willis case, and Andrew Maloney and I will be here to discuss this case as soon as it goes into break. But in the meantime, take a look at Willis.
Basis of that, which is the statistical calculation of a likelihood ratio in the state of New York.
Okay, so, and I'm assuming that in every time that you've testified in court, both as a forensic biologist and in your expertise for star mix, you've been qualified an expert each time by the court?
Yes, I have.
Your Honor, I would move for the admission of Michelle Schmidt being an expert in the area of forensic biology that would include serology, DNA analysis, and the statistical significance of DNA profiling, including the use and understanding of star mix.
Thank you. Well, dear Your Honor. Good morning, Ms. Schmidt.
Good morning.
I'm Fred Johnson. I don't know if we've met or not. I think we may have, but regardless, good morning.
Good morning.
Ma'am, how many times have you been called to testify in the courtroom as an expert?
Gosh, I don't know how many times I've been called to testify. I get many subpoenas that never go to trial, but I've been qualified as a DNA expert over 70 times in the state of Michigan, the state of New York, and the state of New Jersey.
And when you've been called in the state of Michigan, who has called you? Has it been defense counsel or prosecutors or both?
Typically that I've been called in the state of Michigan has been prosecutors. However, in the state of New York, I was called approximately 15 to 20% of the time by defense attorneys.
What's your approximate percent of time called by defense counsel in Michigan?
That would be none.
Thank you. I have no further questions, Your Honor. Now, an objection to Ms. Schmidt's qualification.
All right, she may be allowed to testify with the field expertise set forth in the proffer.
All right, let's, I'm not going to ask you about DNA. We've had a lot of conversation about that, but I want you to talk about what StarMix is.
So StarMix is a statistical software program that assists DNA analysts in interpreting DNA profiles and calculating statistical analysis. The software program looks at all possible combinations of alleles or possible contributors and compares that to the DNA that's detected in a sample to see which combination best describes the evidence that we were able to detect. Using advanced biological modeling and statistical equations and algorithms, each combination of alleles is assigned a weight, and those weights, when given a reference sample, can then be calculated into a likelihood ratio.
And when we talk about reference samples, you're talking about the known samples, right? When you're given a known sample, you input that and it becomes part of that mathematical calculation.
That is correct. When I speak of a reference sample, I'm speaking of a known sample taken directly from an individual.
And is this program typically used for mixture samples? In other words, when we've had some conversation or some testimony about single source findings in this particular investigation. This particular program, is it totally geared towards mixtures, or do you use it in single sources as well?
Typically, we use this StarMix software on mixtures. However, single source DNA samples can be analyzed through the system as well. And I've written reports and testified many times on using the StarMix software on both mixtures and on single source samples. And a mixture is just a DNA profile that is from more than one individual, and a single source DNA profile arises from just one individual.
So the jury had a lot of testimony about the calculations used in single source, the single source analysis. Can you explain to them?
Welcome back to Law News Network, everybody. We're taking a quick break in the Jeffrey Willis case as we revive our audio to listen to what's been happening in that testimony. We're beginning with the Michelle Schmidt testimony. She's a DNA expert going to be talking about in the Jeffrey Willis case. But I want to analyze this case a little bit as we are in a quick break. And I'm here with former federal prosecutor Andrew Maloney. Let's talk a little bit about Willis. We saw some damaging testimony yesterday in particular. I'm talking about that forensic, the bullets that were found. I'm talking about what were fired into Rebecca Bletch's head, because that's what we're talking about here, the murder. That came from a gun that was found in Jeffrey Willis's van and had his DNA on the grip and the trigger. Case closed?
Pretty close. It's pretty close. There's not much room for an argument. If they found other DNA, in other words, beyond his own, one could argue, the defense could argue, yeah, it's his gun, or he's used it from time to time to hunt rabbits or something, but somebody else, he lent it to a friend and it wasn't him. I guess they could come up with some cockamamie excuse for it, but clearly this is his gun, or it was at least used by him at one time. That's what the DNA evidence shows. And if the ballistics match from that weapon in terms of it being the gun that was used to murder Rebecca, I think that's a pretty tight argument for the prosecution that he is the murderer.
Yeah, we were talking about the testimony of Lieutenant Jeff Crump, who's a Michigan State Police ballistics expert. He test-fired the Walther P22 gun that was found in Willis's van, and the bullets matched those recovered from Bletch's head, and the shell casings match those recovered from around the area where she was shot. So it really is not looking great for Mr. Willis. But while I have you here, and I want to ask you this quick question before we go back to Willis, I have to ask you about this pattern. Okay, so we're seeing evidence. It's almost like 3 cases tried in one. We're talking about the disappearance of Jessica Haringa, the potential abduction or almost abduction of this young girl that testified the other day, and the murder of Rebecca Bletch. The prosecution is saying we're showing you evidence of all 3 because we're showing a pattern that this man, Jeffrey Willis, is a serial attacker of young women, and he's into fetishes and strange things. So quick question before, we only have a quick 10, 15 seconds. Is that okay to do, to bring all those cases together, show a pattern?
Yeah, absolutely. He's tied to all 3 of them. So it's not as though they just pulled one out and threw it into the mix, which might constitute unfair prejudice. And there's no doubt this will be an issue for an appeal.
Yeah.
But I think because he is actually tied to all 3 of those cases, it was to show a pattern. I think it was relevant. I think it's important. I think it's fair.
Yeah.
I don't think it's unfair to him. So, for example, I think there's evidence that he knew Miss Huniga. I don't know if I pronounced her name correctly, Haringa, because they knew each other. Because he would stop at that gas station. He's tied to her disappearance.
Exactly, and that's how they're going to tie it all together.
It's fair game to show a pattern. We all know from Silence of the Lambs, the serial killers operate in a pattern and they repeat themselves.
I'm sorry I'm going to have to interrupt, but because we do have our live feed, but that is really important, and we'll think about that, the way they tie all these 3 cases together as they move forward. But yes, we do have our live feed back in.
247. People's Exhibit 248. What did you do in this report?
Again, in this report, I just cut a portion of a swab from a known individual, place it in a tube for further DNA analysis.
Get no DNA no DNA analysis in this particular report.
That is correct.
And I'll ask you the same question. Is there anything different in the marked exhibit than from your original report you submitted to investigators?
No, there is not.
All right, move for the admission of People's Exhibit 248.
Steve?
All right, People's Exhibit 249. What did you do in this report?
In this report, I again cut a portion of a known sample taken from an individual, place it into a tube for further DNA analysis.
You had no DNA analysis done in this particular exam, is that correct?
That is correct.
And sorry, I'll ask you the same question I've asked so far. Is there anything different in that marked exhibit, that report, than the original that you sent to investigators?
No, there is not.
Your Honor, I move for the admission of People's 249.
Steve?
I'm going to hand you what's been marked as People's Exhibit 250. 1 second here. Okay. What duties did you perform in this particular report?
In this report, I perform serology testing, which is typically where I'm looking for blood, semen or saliva, or possibly skin cells. And that was done on container number 34, which was a sexual assault kit taken from Rebecca Bletch.
And in your work, we had, again, Mr. Hayhurst kind of went through the different testing, so I'm not going to go that through, but I will ask the question. In the testing of the various swabs and slides, did you find anything of evidentiary value?
I looked at the vaginal swabs taken from Rebecca Bletch. That did not indicate the presence of seminal fluid, and sperm cells were not observed in that sample. I looked at the oral swabs taken from, and the oral slides taken from Rebecca Bletch. That did not indicate the presence of seminal fluid, and sperm cells were not observed on those samples. I then looked at the anal swabs and smears that, again, did not indicate that seminal fluid was present, nor were sperm cells observed. There was a sample taken from the right shoulder swabs. This did not indicate the presence of possible blood. However, I did cut that sample, place it into a tube, and further DNA testing was done on that item.
So, essentially, you were unable to find, via the chemical testing, the presence of seminal fluid or semen in any of the rape kit items. Is that an accurate statement?
That is correct. I also looked at slides under a microscope and did not visually see sperm cells either.
And certainly, I'll ask you this, Mr. Schmidt, in order to find seminal fluid or the semen itself, one would have to ejaculate. Fair enough?
Seminal fluid and sperm cells do come from ejaculate, so correct.
And if an individual was touched by an object, you wouldn't find the presence of any seminal fluid or sperm cells, correct?
That is correct. If there was an object, I would not be able to detect seminal fluid or sperm cells. However, there also could have been no contact as well.
So my last question to you certainly is this report, which is People's Exhibit 250. Is there anything different in the marked exhibit than the original report you provided to the investigator?
There is not.
Your Honor, I move for the admission of People's 250.
No objection.
Any what's been marked as People's Exhibit 251. Give me 1 second. That's your record 18. What did you do in this report?
In this report, I took a swab of a pair of white headphones, allowed that swab to dry properly, cut it, and place it in a tube for further DNA analysis.
So this is another serology report?
That is correct. No DNA testing was done in this report.
Okay. And again, anything in that report, the marked exhibit, I should say, that's different than the original report that you provided to investigators?
No, there is not.
Your Honor, I move for the admission of People's Exhibit 251.
No objection, Your Honor.
Received.
All right. Any what's been marked as People's Exhibit 252. Give me 1 second here. What did you do in this report?
This was my first opportunity to perform DNA testing on this case, and I performed the DNA testing on the swab that I took from those headphones.
And what were you able to determine based, or I guess let's ask this question, what system did you use and then what were you able to determine?
I tested the headphones using the fusion amplification kit, which is a chemistry that's used in many forensic laboratories across the country.
And what were you able to determine based off of the examination?
There was a partial mixture of two individuals, including one unknown contributor, and he then was able to then compare that major donor, which is the person who donated the most DNA to that sample, to many of the knowns that had previously been processed. The following individuals were excluded as a contributor to the major donor to the headphone swab, and that was Rebecca Bletch, Robert Metcalf, Kevin Bletch, Robert Kinnar, Roger Johnson, Brian Harris, Donald Papera. The minor donor to that mixture from 2 individuals was insufficient for any association purposes, and no conclusions could be drawn.
Okay. Is there anything different in that marked exhibit than your original report that you provided to investigators?
No, there is not.
Your Honor, I move for the admission of People's Exhibit 252. Handing you what's been marked as People's Exhibit 253. What did you do in that report?
In this report, I again cut known samples from individuals, placed a portion of the swab taken from them into a tube, and prepared it for DNA analysis.
And these known individuals, they're all first responders, is that correct?
That is correct.
All right. And again, the marked exhibit, is there anything different in that report than the one that you authored and provided to investigators?
No, there is not.
Your Honor, I move for the admission of People's Exhibit 253. All right, handing you what's been marked as People's Exhibit 254. What did you do in this report?
In this report, I processed the DNA samples from the known individuals from the first responders, and then compared that known DNA from each of those individuals to previous samples that had been analyzed by my colleagues.
And what were you able to determine?
I was able to determine that the DNA profile from Stasia Ripley, Alan Stiles, and Lisa Fairs they were excluded as possible donors to the following items. They were excluded as a donor from the swab of the sunglasses. They were excluded as possible donors to the left wrist swabs. They were excluded as possible donors to the swab from the right fingernail clippings and clippers. They were excluded as possible donors from the left fingernail clippings and clippers. They were excluded as a possible donors from the right wrist swabs. They were excluded as possible donors to the right shoulder swabs. And they were excluded as possible donors to the headphone swab. The one sample I was not able to compare was the swab from the phone holder due to updated laboratory procedures.
And again, I'll ask you the question, in that marked exhibit, that report that's now a marked exhibit, is there anything different in that report than the original you prepared and provided to investigators?
No, there is not.
All right. I would move for the admission of Exhibit 250.
What do you do? Good morning again.
Good morning.
I'm curious, ma'am. I have a recommendation. Let me show Mr. Hilson what I'm talking about. Okay, Ms. Schmidt, during the process of this trial, we get all this information from the prosecutor, and my records are showing something slightly different than what you've described here. Can I show you a couple documents, and they both purport to be record number 21, which is being moved. And my question is, Can you explain to me why those two documents have different dates on them?
The document that I was just reading from, People's Exhibit 244, is dated as a date completion of May 11th, 2016. Actually, sir, you only handed me the second page.
Okay.
I would need the first page of this other document.
All right. All right. All we have is the record number 21 on there in July 19th, 2016. Does that mean anything to you?
Sir, I would need my complete report to make any conclusions about that. I can see that the report I just was reading from, I did need to issue a corrected copy, and the corrected copy is the one that that would have been written after this report. However, I'm only handed the second page of this report. I don't have the complete record with me.
And the report that you handed, that has a completion date of March 25?
The corrected report for Record 21, which is People's Exhibit 254, that has a date completed of May 11th, 2016, and the report issue date was August 19th of 2016.
So the one I have from March, the complete report, that's what you're saying, the one being moved for admission is a corrected report of the March 21 report? That's also numbers 21?
People's Exhibit 254 was a corrected report.
What report does it correct? I guess that's what I'm asking.
It corrects record number 21. There was a mistake written, which I then sent an amended report to correct the mistake that had been issued.
Do you recall what the mistake was?
On this report, as on the black and white copy that I have, I can see that there's a highlighted yellow mark up here that shows it was a corrected report. And turning to page 2 of that corrected report, I see I updated the conclusion for item 2X, the swab from the phone holder, and that was not compared due to updated laboratory policy. And that is also highlighted here and highlighted on my report in a black and white copy.
Do you have any idea how many times you corrected this report? Because the March 21 report, that I'm 25 report, also says corrected copy.
This is the same report that we're speaking of. Item People's Exhibit 254 is the corrected report.
Okay.
Every report that gets issued would be sent to the prosecutor, which is then given to the defense counsel. So if he has 2 copies of record number 21, it was corrected one time. There was the first report that was issued that had a mistake, and then the second report that was corrected that has the corrected information and is noted at the top of the report as the corrected copy.
And the corrected copy, what's the date of that one again?
The corrected copy has a date of May 11th, 2016, with a report issue date, which is on the bottom of all of our reports, of August 19th, 2016.
I think that's probably what's confusing me. This report also indicates it's corrected copy, but it has a March completion date. Can you explain why the 2 dates are different for one corrected copy?
They're not different. There's multiple dates on each of our report. He's looking at the date received, which is March 25th, 2016. I'm looking underneath that date. If you look at the very top portion of the report, there's a date received, which is March 25th, 2016. Underneath that is a completion date, which is May 11th, 2016. And at the very bottom, after it's gone through all of our technical and administrative reviews, we have an issue date in which my electronic signature is placed on the report and sent out to the agencies. And that report issue date is at the very bottom of each page under that paragraph that looks like it may be italicized. And that report issue date is August 19th, 2016. It's right above the page number.
Thank you. Thank you. I have no further questions. I do not oppose the admission of it.
Okay, 253 will be received.
I think that's 254, Judge.
I'm sorry, 54.
Okay. you what's been marked as People's Exhibit 255. Can you describe what that report is, please?
This report is another serology report where no DNA analysis was done. And in this report, no serology was done either. There was a container that was submitted, container number 42, that contained contained evidence item 45037 containing the hair tie and pulled head hair, and nothing was done with this. This sample was not analyzed and returned to the agency.
Anything in that report that's the marked, exhibit report that's different than the one you supplied to investigators, the original?
No, there is not.
Your Honor, I move for the admission of People's 255.
No objection.
All right, handing you what's been marked as People's Exhibit 256. Can you tell us what that is, or what you did in this report?
On this report, I processed the DNA sample from Rebecca Bletch in the other amplification system, the fusion amplification system, and I also processed a DNA sample for DNA comparisons of Ellie Bletch, who is the daughter of Rebecca Bletch.
And what were you able to determine?
When I compared the DNA profile of Ellie Bletch to the partial DNA mixture obtained from the headphone swabs, it was determined that the DNA profile of Ellie Bletch matched the major donor to the DNA obtained from the headphone swabs. And I performed a statistical calculation on that as well.
All right, and what was that?
This statistical calculation shows how rare the DNA profile would be given the general population. It's done looking at 3 different population databases. The first population database is the Caucasian database, and using the available data, the probability of selecting an unrelated individual at random from this population having a DNA profile matching that of the major donor to the headphone swab would be 1 in 2.619 million. In the African American population database, selecting an unrelated individual at random having the same DNA profile matching that major donor of the headphone swab would be 1 in 7.508 million. And that same statement using the Hispanic database would be 1 in 7.199 million. I then compared the DNA profile of Ellie Bletch to other items that had been previously processed by my colleagues, and the DNA profile of Ellie Bletch was excluded as a possible DNA donor to the following items: to the swab of the sunglasses, the left wrist swabs, the swab from the right fingernail clippings and clippers, the swab from the left fingernail clippings and clippers, the right wrist swabs, the right shoulder swabs, and again, the sample from the phone holder, the swab taken from the phone holder, was not compared due to updated laboratory procedures.
Okay, anything in that exhibit, the marked exhibit of your report, that's different than the original you sent to investigators?
There is not.
Your Honor, I move for the admission of People's Exhibit 256. All right, handing you what's been marked as People's Exhibit 257. One second here. What did you do in this particular report?
In this report, I examined 2 possible hairs or fibers, and both of my findings were that the possible hairs were not human in origin.
All right, so there was no need for any further analysis.
Correct. No further analysis was done on possible hairs that were not human in origin.
All right, anything different in the marked exhibit report than your original submitted to investigators?
No, there is not.
Your Honor, I move for the admission of People's 257.
Okay, and with that, we're going to have to take a break. Remember, I told you there were some other cases that I have to address. We're going to do that now. So let's take a break. You may stand down. Okay. You want to bring? Okay, please. You already talked to them.
Oh, sure. Is there any way?
Welcome back to the Law News Network, everybody. This is Jesse Weber. Thanks for joining us. There's a quick break right now in the Jeffrey Willis trial out of Michigan, but that's okay because we want to analyze what we've been hearing so far in this case. And to help talk a little bit about what's been happening in this case, we have with us today, we're very fortunate to have with us today, former federal prosecutor Andrew Maloney. Let's talk a little bit about Willis. We were cut off before. We were talking into that idea. There's evidence of 3 different cases in here. And I don't know how much time we have before we have to go back. But again, what we were talking about is there's evidence about Rebecca Bletch's murder. There's evidence about this teen abduction. And then there's evidence about the disappearance of Jessica Haringa. It's an unusual case because it looks like you're trying 3 cases in one. And I had to cut you out before, so maybe we could just talk a little bit more about what that is, that idea of 3 cases in one.
Yeah, look, I think most people are familiar that some serial killers have a pattern and they use sort of the same MO, and that is exactly what the prosecution's arguing here. The jury's being asked ultimately to determine whether or not he murdered Rebecca Bletch, but this other evidence has come in and because it's relevant. It's arguably relevant to this pattern. Now, it's obviously very prejudicial, and so the defense has argued it shouldn't have come in and it prejudices unfairly their client, and that's going to be an issue for an appeal if he's convicted. But that's the touchstone. Whether or not it's not whether it prejudices him, it clearly does. Any evidence will prejudice a person on trial. The question is whether or not it's unfair. In other words, is it unfair for the judge to have allowed the jury to hear that other evidence? And in this case, I think because he's tied to all 3 of those cases, it's relevant, and it's not unfair to him because he was connected in some way to all 3 of these cases, in some more strongly than others. And so I think it's fair for the prosecution to have asked the judge to allow that evidence to reach the jury, and it's fair for the jury to consider it. The case, particularly against Jessica, which was older, is probably less clear, and the jury's not going to be asked whether or not he's guilty of that crime, but they are trying to establish motive and pattern, and I think it's fair for them to do that by showing his connection to Jessica because he knew her. He visited her at the gas station, and then she suddenly disappeared. And
remember, this is just the first trial. He's charged in connection with those 2 other crimes, so he's going to have those trials as well. I want to ask you, what do you think, in your opinion, is the most damaging evidence that the prosecution has? Is it what we talked about before, that those bullet casings match the gun in his possession? Is it the folder? labeled VICs, which is short for victims, and subfolders. This was in his house. It has the initials of Rebecca Blech and Jessica Horinga. I mean, is it the amount of paraphernalia that he's had in his possession, the dark history that he's had, his search history? What do you, in your opinion? Is there so much far to this guy? I don't know where to begin.
Well,
what's
yeah,
what's the most damaging part?
There's a lot of damaging evidence against him. I think that the DNA evidence that shows his DNA on the gun, and that gun being tied to her murder, used, in other words, not so much the casings itself, because there are 22 caliber casings, but the ballistics. If the bullets and ballistics match, in other words, the bullets that actually were used to kill her match the ballistics forensically, or at least close enough to his gun, that to me is pretty powerful. That's probably the most powerful piece of evidence that directly ties him to her murder.
Yeah.
I haven't heard any excuse as to why he had that gun and whether or not that gun was the murder weapon. It seems to be pretty clear that it was the murder weapon and that his hands were on it, at least at one point in time. And I haven't really heard any other defense to that. That, to me, is the most overwhelming piece of evidence in the case.
Yeah.
The other stuff is adding fuel to the fire, gravy, if you will. What they found on his computer in his house, the VIX folder, I mean, that's kind of unusual for somebody
would you
to
have
keep
that?
that.
Yeah.
That alone might not get you convicted, but when you start adding it up with these other things, it's pretty damning. It's pretty damning evidence.
It chops into that reasonable doubt. That's what it
yeah.
does, right?
Yeah.
I mean, let's not forget, a handwriting analyst said that Jeffrey Willis wrote a note found in a trash barrel in his late grandfather's house. And the list, according to earlier testimony, had such things written on it as handcuffs, sex toys, gasoline, matches, ball gag, and in quotations, her panties, as well as neck restraints and cameras. What kind of party was this guy into? It's one that I don't think anybody wanted an invitation to.
No, and particularly disturbing is the gasoline. I mean, there are people that are into kinky things, and sometimes you have consenting adults, but there's no explanation as to why you have gasoline, other tools that you would use to dispose of a body.
Yeah.
Once you've had your fun and you've murdered the victim, you want to dispose of the evidence in the body, and that's what the gasoline would be used for. So that, I mean, say what you want about people's sexual predilections. When you have somebody who's disturbed like him, who is kidnapping people against their will, restraining them and murdering them, and then disposing of the body, or at least trying to, that's what it looks like he was planning to do with gasoline, that becomes very disturbing.
It's also disturbing because Jessica Horinga's body was never found.
Yeah.
We don't know what happened, and that's really what adds it adds a flavor to it. That list. I want to talk about. Let's talk about Kevin Bloom, who's the other person that that the defense is pointing the finger at. That is Jeffrey Willis's cousin. Now, I have to tell you, from what I've seen, it doesn't really seem like he was implicated in the Rebecca Blech murder. In fact, according to other important testimony that we saw in this case, Bloom was at his daughter's sand soccer tournament in Grand Haven at the time Blech was killed. This is according to a sheriff's detective who testified. So that raises questions about the defense's theory here, and I haven't seen anything connected to Rebecca Blech. Now, was he connected to Jessica Horinga? Was he connected possibly to that abduction? Maybe. But all I've heard so far from the defense is that, and they haven't put on their case yet, is that Mr. Bloom is his cousin. He's an expert marksman. He might have had been connected in connection with this crime, but and that he also knew Kevin Blech, who is the husband of Rebecca Blech, and that they might have been in some sort of plan to kill Rebecca together. But does that really fly from what you've seen so far?
No, it seems desperate. It seems like what we would call a shotgun approach to throwing stuff up on the wall and hoping something sticks or resonates with at least one juror to create room for reasonable doubt. Talked about this earlier in the Toledo case. It's a common tactic that the defense team uses. They'll try to point the finger at somebody else, whether they have evidence or not. The attorney will make an argument that he or she thinks might resonate with at least one juror to say, wait a minute, we didn't hear about this. Maybe that's reason to doubt. It usually doesn't work unless there's some teeth behind it, and it doesn't sound like there is here.
Yeah, it's not looking great. I mean, for him, and the idea that he might have well had a connection to some of this other information, maybe perhaps the Jessica Haringa situation, because we know that he was charged first with lying to the police, and then he was convicted of that, and then it was also he became an accessory after the fact in connection with that that issue, because he apparently knew where the body was and he was involved in that way. But this creates a danger, and I'm curious, if I'm sitting on the jury and I'm weighing through all these facts, I don't have the ability to look up articles, watch LawNewz.com, hear about our analysis. If I think Jeffrey Willis tried to kidnap this young girl, we saw that testimony earlier, and she pointed him out in the courtroom, that's the guy who tried to kidnap me. How dangerous is it for the defense to be like, if he's already convicted in the minds of the jury on one of these, then he's convicted in terms of Rebecca Bletch? What's that danger?
That is the exact argument we were talking about before, the legal argument that it was an unfair prejudice to him. In other words, he's got to defend himself on 3 different cases, arguably that have nothing to do with each other. Of course, the prosecution looks at it differently. This is a pattern. This is a depraved individual that can't stop himself. And we know that there are people, unfortunately, out there that are like that. So from the defense perspective, they're saying that's unfair. I've had to defend myself against this teenager who that would be its case by itself, but now I've got to defend myself against these other 2 murder cases, and it's unfair for me to have to do so all 3 at the same time. And it's an argument for an appellate court to have to deal with and unscramble, but I think the prosecution and the judge made a rational decision that it was fair under these circumstances. So I think once the jury has heard all those 3 things put together, I think the evidence is overwhelming. The question is, are they unfairly viewing these other 2 cases, and maybe they feel like the evidence against Rebecca's murder is weak, but it's now bootstrapped and bolstered by these other 2 cases. That would be something the jury really shouldn't be doing. They should be determining whether or not there's enough evidence to convict him beyond a reasonable doubt on Rebecca's murder. If it was her case alone, what would that case look like? I still think it's pretty good. Mm-hmm. There's a danger that the jury has now been unduly influenced and improperly by considering evidence of these other cases that might be unfair.
Let's talk, we talked about 3 women here that are involved in this case. What about the other woman in his life, Charlene Bishop, who was married to Mr. Willis? She testified a few days ago, and we know in the law that if you're married to somebody, you're not forced to testify against them, but she's divorced from him. This is someone who knows his darkest secrets. What she said was, I thought it was interesting, maybe you could talk about a little bit, the idea that he was, he contacted her after his arrest, and she felt that he was relaying the information about his day, and she felt that he was planting memories, trying to develop an alibi.
Correct.
Maybe could you speak a little bit about what she testified to?
Yeah, she felt that he was reaching out to save himself, to try to get her to help him and create an alibi. And if not to convince her to lie for him, at least to try to plant some seeds in her mind, and maybe her recollection would be fuzzy and hazy, and maybe she says, yeah, I kind of remember that, or that's what she felt he was trying to do, to plant memories that never occurred, or trying to convince her that this is what happened and her to go along with it. She clearly wasn't doing that. She was having none of that. I think the fact that his own wife, ex-wife, has not supported his version of those memories or those events is another damning piece of evidence. He's reached out to try to get help from somebody, and he's got just the opposite.
The interesting thing about this case, besides the many different disturbing details of it, and as we've talked about, it's almost 3 cases in one. We talked about in the break that he keeps committing these crimes, or if we want to take the fact to assume that Mr. Willis does keep committing these crimes, he's committing them every 2 years or so. But he's been using the same kinds of things. It's that minivan that keeps coming up in the Haringa disappearance, in the potential abduction of that teenager. It might have been used in connection with the Rebecca Bletch murder. If we talked about this, if this is a guy who has has a predilection for injuring and hurting and kidnapping young women, wouldn't he try to do a different kind of, not use the same kind of materials, not use the same kind of cars, try to switch up his attacks a little bit, but he's using the same thing?
You're thinking like a rational, logical person that is trying to avoid being caught.
Right.
I don't know what's going on in his mind, and he may not be thinking that. Maybe he wants to be caught. But keep in mind, After the first 2 murders, he's not arrested. Time goes by, he thinks he's in the clear. He kidnaps the teenage girl, and she gets away. And you would think then he'd say, uh-oh, they're going to be after me now for sure. Let me get rid of all this evidence. He doesn't do that. And a month goes by, he doesn't realize he's being watched. He thinks he's in the clear again. And so why change your pattern when I've gotten away with it 3 times until the police finally come down on him?
Yeah, well, it's. I'm glad we're trying to get some answers to this, because this is a guy that was terrorizing this area in Michigan. And as I said to you, I went to school in Michigan. I only want good news coming out of Michigan. So the idea that maybe this can, if this is the gentleman who really did commit these crimes, having him on trial for these separate incidents is fantastic. I do want to talk a little bit more about this case, but just to give our viewers a brief recap about where we are covering the Jeffrey Willis case. Jeffrey Willis right now is on trial for the murder of Rebecca Blech. He's accused of shooting her several times in the head alongside Automobile Road in rural Muskegon County, Michigan on June 29, 2014. It was believed that she was jogging at the time. And as we were talking about earlier, prosecutors say that the motive was to kidnap, sexually assault, and kill this young woman, as they say he did to Jessica Haringa. She had disappeared from her gas station job in April of 2013, and as disturbing as this is, and as we kind of hear it in the Toledo case, which we're covering as well, her body has never been found. So he's not only been charged in connection with Rebecca Blech's murder, the disappearance of Jessica Haringa, but as we also said, he's charged in the abduction of a teenager who was walking along a rural Muskegon County road in April of 2016. She was 16 at the time. She testified earlier in the week, and she pointed out in the courtroom that Mr. Willis was her potential abductor. So luckily she was able to escape him, but that investigation ultimately led to Willis. He was arrested in May of 2016. We'll talk about that in a little bit. I also want to give our viewers that we are in verdict watch in the Luis Toledo case out of Florida. This is a man who's 35 years old. He is charged with second-degree murder in the killing of his wife, Yesenia Suarez, and 2 counts of first-degree murder in the killing of her 2 children. They're there right there, Talia and Michael. And if he is convicted of killing those children, he does face the death penalty. That is a separate trial. That is a separate phase, a whole different issue. We know that the jury was instructed by the judge, given jury instructions earlier today at around 8:30 a.m., lasted for about an hour. As we talked about, it's an early Friday morning jury instruction. I wouldn't be surprised, ladies and gentlemen, if you do get a verdict in the Luis Toledo case pretty soon. The evidence put forth by the prosecution was very strong. The defense, in my opinion, didn't have much to go with. So do not be surprised if we do get a verdict, but we will be here on Verdict Watch, so stay tuned to LawNewz to see any developments in that case. Also, I do want to let you know that a little bit later today, we will be covering the Tiger Woods case. Tiger Woods is going to plead guilty to that DUI charge earlier this year. And remember, he was driving under the influence of prescription medication, and you saw that video. He was walking, he was stumbling, but he is going to plead guilty and enter into a rehabilitative program. We're going to cover it here on LawNewz. In the meantime, as I said, we're here with Andrew Maloney, our former federal prosecutor here for the day. I do want to talk a little bit more about Willis before we go into a brief clip. This idea, okay, this I have to mention to you. This is a guy who collected the underwear of a woman that he knew. Michelle Shontala identified 2 pairs of underwear found hidden in Willis's shed, and as well as the handgun that was recovered from his van. But she said that all the items were kept in her closet, and that there was evidence that Willis had been outside her home while she was gone. She's a co-worker of Willis, and he had asked her like 50 times for a pair of her underwear. Okay, if I'm the defense, can't you just say this is a guy? He's not right. He's sick, okay? He has an obsession with, submissive sexual acts. He wants women. He's a pervert. But there's a strong line between a guy that watches all these things and does all these things and maybe has an obsession with women that are abducted to a guy who's really a killer and a violent offender. Can't you just make that argument and say, he might be not a right guy. You might not like him. You might not agree with his fetishes. But this isn't a killer. I mean, the more evidence that I hear, how much of it is just saying, you know what, it's too prejudicial for this guy. We got to talk about the hard, concrete DNA evidence and testimony in this case.
Well, that is the danger the prosecution has, and sometimes judges will deny a prosecutor's request to, basically lump it on the dump truck of evidence of that anything that makes him look bad. The danger becomes you've now gone from fairly prejudicing him with evidence to unfairly prejudicing with evidence that's out there. So, assuming all that what you just said is true with the coworker, is it directly relevant to proving he murdered either of these two women or kidnapped the teenager? Probably not. As you indicated, there are people out there with fetishes, and if I'm the defense lawyer, I argue, well, okay, he might have had a fetish, but he didn't kill the coworker, he didn't kidnap her, he didn't mistreat her. He's not a violent guy. He just has maybe a sexual kink side to him that some of us don't understand or appreciate, but there's no crime in that. So you could spin that if you're a defense lawyer, but the problem, I think, is it becomes too weighty. The evidence, all the things that would turn off the average citizen saying, hey man, this guy is depraved, and it's not much of a leap to go from that to kidnapping women, sexually assaulting them, bound and gagging them, and then ultimately he's got to do, he doesn't want to witness, so he's got to murder them and dispose of the body. It isn't that much of a leap, but is it a fair leap? That's the question. That's probably going to be a question for an appellate court if he's assuming he is convicted.
Well, as we said before, there's evidence of like restraints, leather restraints, and a ball gag. But from what we've seen so far, there's only been his DNA on that, none of the victims in this case. But again, he might not have, if he shot Rebecca Bletch in the head and he wasn't able to really have this teenage girl in his car for very long, and we don't know what happened to Jessica Haringa, it might make sense that their DNA is not on these items. But as you said, it's something for the jury to consider moving forward. I want to analyze a clip with you that we have because we are talking about the Jeffrey Willis case. So let's start from a little bit from the beginning. Michelle Clint was actually the person that found Rebecca Bletch on the road. So let's start from the beginning, what she found. This is a clip from earlier in the week when this case first started out. We do have our visual for this one, but again, as soon as we have a live feed in the Jeffrey Willis case, as soon as testimony resumes, we'll make sure to turn to it. But in the meantime, we are going to analyze some of the clips that we've seen and some of the testimony, and here is the testimony of Michelle Clint.
Do you recall leaving your home around the 6 o'clock hour on that particular date?
Yes.
All right. And in what direction, first of all, who were you with?
My husband and my daughter.
And in what direction were you traveling?
South.
All right. As you're traveling south, well, first, I apologize. Do you know somebody by the name of Rebecca Bletch?
I do.
And how do you know Rebecca?
She's one of my neighbors. She was my daughter's basketball coach.
So she's a person familiar to you?
Yes.
Okay. On that particular date, June 29th, 2014, you're traveling south on Automobile Road. Describe what you see as you reach the intersection of Automobile and Riley Thompson Road.
Saw something on the side of the road.
And initially, what was your thought?
My husband made a comment that he thought it might be a deer.
Okay. As you got closer to the object, tell us what happens next.
I realized that it was a person.
Okay.
Laying there.
And what did you do?
We drove a little bit closer, and I got out and ran over there while my husband was in the car with my daughter.
Okay.
And when I realized that it was a person, I said, we need to call 911.
All right. Could you describe for the jury, when you initially come upon this person lying, well, let me ask you this, if you could describe kind of where the body was in relation to the road.
She was partially in the road. I think more her head was towards the gravel.
Okay.
She was not face down totally, but her head was turned to the right.
Okay. So you see her and she's lying on her stomach. Is that safe to say?
Yes.
Now, being a nurse, did you recognize or did you make any observations as to potential injury?
I could see that there was blood on her head.
Okay. Now, could you describe also for the jury, you described the position of how she was laying on her stomach. Any other observations you noticed about her or her clothes that you can recall?
How she was on the side of the road, her top was up a little bit, and her bottoms were down a little bit so that I could see the top of her buttocks.
Okay. And did you, at this point, did you know who it was?
I did not.
Okay. Now, I'm assuming, well, I don't want to assume. Did you do anything to, because of your training, did you do anything to see if there were any vital signs at this point?
Once I got to her, I could hear her somewhat like moaning.
Okay.
And obviously she was breathing at that point, and I checked her pulse.
Okay. And what were you able to determine from that?
I felt that it was pretty regular, although it was fast.
Okay. At some point in time, does somebody call 911?
Yes, my husband did.
Okay. I'm going to play that here in just a second. I want you to look at, well, let me ask you this question before I show the photograph. When your husband calls 911, at some point in time, is there a decision made about moving the body in some fashion?
Because I thought she was struck by a car. Being a nurse, I know that sometimes you don't move people. Her pulse was regular, although it was fast, and she was still making noise. Whether it was moaning but breathing was regular. I didn't feel that I should move her at that time.
Okay.
And my husband wasn't right there with me either, so I couldn't have done it by myself.
I understand. At some point in time, is there a decision made to actually move her?
There was.
All right. And was that before or during the 911 call?
It was during the 911 call.
All right. I want to show you what's marked here as People's Exhibit 1. This photograph right here. Are you in this picture?
I am in that picture.
Okay. And is this a photograph of? At this point, is it safe to say that Miss Bletch has been returned from her stomach to her back?
Yes.
All right. And when that was done, was that in attempts to do some sort of CPR or other life-saving measures?
Yes.
Okay. What did you do?
To get her to that position.
Well, yeah, okay. Good answer to a really bad question. Let's just, for sake of assumptions, the body has been turned over. Did you do anything at that point in time as it relates to any life-saving measures?
Prior to, I was in the position that my husband was
Okay.
when we turned her.
Okay. And so you were doing what?
Maintaining her spinal cord.
All right. And was your husband doing the compressions at that point in
He
time?
was not.
Okay.
Because we hadn't turned her over yet.
I understand. At any point in time, then, did you engage in any life-saving measures, CPR or anything else?
Not until we turned her over.
Okay. Now, your husband's on the phone with 911, and ultimately, or at some point in time, who arrives on the scene?
Bob.
Deputy Kadar?
Yes, I'm sorry.
That's okay. Was he the first responder to appear?
Yes.
Okay. Now, besides, well, let me ask you this. At some point in time, or at what point in time, did you realize that this possibly was or was Rebecca Bletch?
After the first responders arrived and I was able to look, and one of the first responders had identified her as Becky.
Okay. And is at that point in time you were able to kind of match with what you had seen with that identification? In other words, again, bad question, I apologize. When that phrase was uttered, were you able to recognize the person you had been attending to as Rebecca Bletch?
I was.
Okay. All right. Besides where Rebecca's body was, did you notice anything else unusual on the roadway?
There was a pile of items over on the other side of the road.
All right. Did you ever get a chance to see what those items were?
It looked like a pair of white sunglasses, if my memory serves me correctly, and like a band that would go on your arm, maybe your phone or whatever.
At that point in time, did you know at all who those belonged to?
I didn't.
Okay. I want to play for you. All right, now hopefully speakers work.
Where is there in the corner of Riley Thompson and Automobile?
Can you hear that, Mrs. Clint?
I can.
Can you folks hear that? Do you know, do these microphones amplify, Tom, or?
They do. If you put the speakers towards the microphone, you should.
All right. Let's see if that helps. Before I press play again, did you recognize that voice?
Yes, I did.
And who is that?
That was my husband, Mark.
Okay.
On Automobile Road. We come up to this lady, she's laying in the road. I think she was hit by a car.
Okay.
She got a head injury.
Okay, so I'm at Riley Thompson and Automobile?
Yeah,
Is
on
the person
Automobile Road.
Okay, which way from?
4300 Automobile Road.
4300 Automobile, okay. Stay on the phone here with me, okay? I'm going to get some help right out there for you. Did you see what happened to her?
She had the pulse. We just came up on her.
Is she unconscious?
Yes, she is.
Okay, you stay on the phone with me. Is she breathing?
She is breathing, she has a pulse.
Okay, did you see who hit her? Does she have obvious injuries?
She has a head injury.
Okay.
She's got a head injury and she's laying face down.
Okay, don't move her around, okay?
Yep, we're not moving her around.
Okay. Is she by herself?
You need to hurry, she's all by herself.
Okay.
It's really irregular. My wife is a nurse. So
Okay, sir, I got a help that's going to start up. Okay.
Okay.
What's your name?
My name is Mark Flint.
Okay, Mark, someone else there started some help. I'm going to save them up about what's going on, okay?
Okay. I don't know what to do.
Okay, sir. Mark, what's your phone number?
6700927.
Okay.
You need to hurry.
Okay, sir, they're on the way already, okay? Did anybody see anything?
What else? I don't know what else to do.
Okay, sir. Just tell me if she's, okay.
Her pulse is really weak.
Okay. We call?
She has not been moved, but she's halfway in the road.
Okay. Get your
The
car.
road is not busy.
Okay. What kind of car are you in?
I am in Toyota Camry, urgently.
Okay.
I'm right in the middle of the road, nobody's gonna get by me.
Okay. Get your flashers on. Get your flashers on?
Yes.
Okay. Does she, ask your wife if she thinks she needs CPR?
Does she need CPR, Michelle? Does she need CPR? She's still breathing, and she has a pulse.
Okay. Tell your wife that if she needs CPR, I can help her with that, and I will stay on the phone with you. The fire department and the ambulance are on the way.
Okay, no, Michelle, just leave her. If she's got a pulse, she's fine.
Okay. I need to know if she's breathing normally. It's just
She's
her.
breathing normally, Michelle. She is not breathing normally.
Okay. We want to start CPR then. Tell her to go ahead and start with CPR.
She's on her chest, and Michelle would have to turn her over.
Okay, what we can do then is we can move her over, but I want her to be real carefully when she turns her over. I want you to stabilize her head, her neck, and her back.
Stabilize her head. You know what? There's another car coming. Maybe I can get them. She's a business.
Okay,
They're on the way, Michelle. They're on the way.
okay. I can help her with it.
She's just a little paranoid and move her.
Okay, I understand. Okay, if she doesn't want to move her, that's fine, but if she's not breathing normally, then we're not going to hurt her anymore.
I don't know if we should move her. She's got a pulse still.
Okay, tell her to use her best discretion if she's a nurse.
Michelle, use your best discretion what you should do. She's got a really bad head injury.
Okay, she's bleeding from her head.
Yeah, she's bleeding quite a bit from her head.
Do you see anything around her that would...
She's got blood coming from her ear. That would be her right ear.
All right, I'm going to check with the supervisor here real quick, okay?
Okay?
Okay. What I want her to do is I want her to turn her over. We're going to do CPR. We're not going to hurt her anymore. She's got that bad of a head injury and she's not breathing normally.
Okay, I'm going to put you on the voice so she can hear.
Okay. Okay. Michelle, can you hear me? Okay. Okay. We got to start CPR. If she's not breathing normally, I want you to go ahead and start. We're not going to hurt her anymore.
Oh.
Can you do that for me? I can stay on the phone and help you through it. Okay.
You need to roll her body from, you just got to move her here, Mark, and see her hips and her shoulders, and I will roll her head. Okay.
Okay, Michelle, you're doing it good. Once you get over, I want you to look at her mouth and see if...
One, two, three. Oh my God.
Okay, is she getting any air? Is she breathing?
Not.
Okay, is CPR going to help?
I'm going to open her airway. I'm doing a jaw thrust on her.
Okay, you're doing a great job, Michelle.
She's not breathing, no.
Okay, I want you to start with CPR, okay? Do you remember how to do it?
I remember how to do it. My husband's going to have some over her.
I got her.
Okay, you guys are doing great.
Grab her behind here.
Right.
Hold tight. Just hold her tight and go get your airway opening her. That's steady.
I'm here for you if you need anything from me.
All right.
Stay there, Charlie.
Michelle, make sure you get 50 deep breaths in her.
Yep. I can't. She's got blood out of blood.
Okay.
I don't have anything to.
Okay, you can just do chest compressions. You don't have to put air in her mouth, just go to chest compressions. You guys can take turns if you need to.
Oh, she's making funny noises.
Okay. Okay, that's fine. You're not going to hurt her if she's not breathing. Just go ahead and do chest compressions. Let's get that blood to her.
Okay. Where is she?
They're on the way. It's 4300 automobile, right? You're going to hear sirens real shortly. Okay. You're going to hear sirens real shortly. They're driving there. Did somebody else stop now? Okay. You guys are doing great. I know it seems like it's taken a very long time. They're driving there as fast as they can. You guys are doing great. You can take over for her if you need to, okay?
Keep going.
Oh my gosh, you can do this.
You're doing great, Michelle.
I know, but who can get it when you just need her?
Okay.
Hey, I'm starting to hear some,
Yeah, those are for you. I know this is hard. You're doing great. Hold together just a little longer, okay? Huh? You can help her, okay? Are you helping her? Okay. Okay. Do you hear the siren? I want you to keep doing the chest compression so someone takes over for you. You guys are doing great.
Oh my gosh, there's keep going, Michelle.
Keep doing it till he gets there, okay?
Get ready.
He's gonna get some stuff out. He's gonna be right there for you.
No, I'm not keeping her.
Keep it going. Okay, thank you. Okay. Mark?
Yeah.
Mark, your phone number 767000927? Okay, you guys did a great job. I'm gonna let you go and have them take over for you. All right, thank you, sir. Bye-bye.
I want you to take a look at exhibit number 2. This photograph. You recognize that the vehicle in that picture?
Yes,
And whose vehicle is that?
that's our vehicle.
All right. Is that approximately where you had parked prior to you getting out and checking on Miss Bletch?
Yes.
Now, in this particular photograph, is it safe to say we have ambulances already arrived, EMS, and some other folks? Is that about right, what you remember?
Yes.
And is it safe to say you had parked behind the body, is that right? In front of the body.
Yes, we stopped here and she was.
Yeah, she was in front of you. Body was in front of you. So in this particular photograph, at some point in time, do you recall the body being moved from the roadway?
Welcome back to the Law News Network, everybody. This is Jesse Weber. We're cutting out of that prior testimony in Willis because we actually have some activity in the Luis Toledo case out of Florida. So take a look. We'll be back here with more analysis.
Go ahead and bring Mr. Toledo out. If you have a phone or any electronic device, please make sure it's turned off, okay? All right, let's get started. I've received 3 inquiries from the jurors. One is a simple one.
please order lunch. So we're going to go ahead and order lunch for them. I did write a response to them, and this is what I wrote to them. You have with you these jury inquiry forms. Please use the jury inquiry forms to make requests or ask questions, because they're writing them on just a sheet of paper. And I think these things need to be part of the record. So that was my answer to that. Second question we got from them is, can we have the timeline chart? I'm going to respond that the timeline chart was nothing more than an illustrative exhibit, that they have the evidence. They must use the evidence to develop their own timeline. Any objection to that? Okay, this is my answer to that. The timeline chart was an illustrative exhibit only. It was not evidence. You must use the evidence to develop a timeline if that is what you need. Anything else? Want me to add to that? All right. The third one was, can we have the overview map of the entire area that showed the 7-Eleven, dumpsters, Publix, and the brother's house? I thought they had a map that had the whole area. No, but there was a map that they took.
That was only the search area. They didn't show the.
I remember.
There's more than one. I think the way that's in now, more than one county.
Well, if there is.
I understand, and I was. I know there was a map, I think, that showed the driving route. I know there was a big map of the entire area that I know came into evidence.
There was a map of the drive routes, but it didn't have any of the locations
Pinpointed.
on there, and that's what they're asking for. Because there's a separate map that was only allowed for demonstrative purposes, or demonstrative purposes only. It has the pinpointed locations of all of the places of interest.
Okay, well, how do you want me to answer this?
I think it's appropriate to give a similar reply as you gave to the timeline. It was an illustrative exhibit.
Okay. You know, I question whether or not just a general map, but I don't think there was any evidence of addresses, right? In the trial, I don't.
There was evidence of streets, but never a precise address. It was this person lived on this street in this location, but never the numeric address, except for the girls across the street from Mr. Toledo and the house itself.
Right. I'll have to, I'm going to answer it for now, but I'm going to do some research on it to see whether or not, sometimes I think they can get maps and things that have no labeling. I think the reason why I excluded is because it had labels on them. So. So my answer is the maps that you saw were illustrative exhibits. You must use the evidence to answer any issues. The maps in your possessions are the evidence. Any objection? I'm sorry?
No, sir.
Okay. Okay. He's back to them. All right, then we'll be in recess until we get another question. Graham, who's in charge of lunch? Very well, okay. Go ahead and take them. Yeah, on the record or?
Weber, so you just saw in the Luis Toledo case some jury questions that were put forth. One was, when are they going to have lunch? But the more important question was, they want a timeline, a timeline of all the events that took place and an overview map of the entire area where everything happened. And there's some reasons why we can assume they're asking this question. But I'm here with Andrew Maloney, our former federal prosecutor for the day. My understanding of this, and correct me if I'm wrong, is the reason they're asking for the timeline, the overview, is really to try to talk about what the defense pointed yesterday was that Mr. Toledo wouldn't have had the time to commit this crime and clean it up in the way that they said. But that's what I assume. What do you think?
Yeah, it's hard to read the tea leaves when you get a jury note, but I think your assumption is probably accurate or certainly plausible because some jurors, it could be just one juror, it could be a lot of them that have a question about what the defense argued. And sometimes it's just a matter of them literally picking apart the defense's argument, and this may be a way to do it. Sometimes it may be a juror that credits the defendant's argument and says, hey, look, let's see this evidence and I'll show you how it's impossible. In other words, they buy the defense argument, and the other jurors have to listen and maybe rebut that and come back and argue during the deliberations that it doesn't show what that juror remembered it. So you have 12 people. Their recollections of a long trial of certain pieces of evidence may differ from one another, but that's what they're there to talk about. That's what they're there to debate in their deliberations. And sometimes one or two of the jurors needs to see that evidence again because they've forgotten some of the details. So it may be something that the defense team thinks, oh, this is great. They're looking at our case. This is good for me. Not necessarily so. It may be just they're deconstructing the defendant's arguments, and they want this evidence to be able to put it up there and discuss amongst themselves and then dismiss it.
Because at the end of the day, it's not really that strong of a theory that they put forward,
Right.
that he didn't have the time to do this. So another way of looking at it is, and we talked about this earlier, we wouldn't be surprised if we see a verdict today. So if they're trying to get away with that defense and make sense of what they said and said, wait a minute, you know what, he did have the time to do it, we might be seeing a verdict very, very soon.
After lunch.
After lunch. They want that lunch.
They want
that lunch. Quick question just generally, when you're sitting on a jury, how much of the exhibits or evidence are you allowed to see? I know there's a question about some jurors allowed to take notes, sometimes you're not, but how much are you allowed to take with you or request into the actual room?
You are permitted by law to see every piece of evidence that was admitted into evidence. There is, that includes testimony. You can have readbacks of testimonies. They usually do that in the open courtroom. But there is the note that was just referred to asked for something that was demonstrative or illustrative evidence. So, for example, if a witness or even the lawyer during the summation puts up a chart and summarizes some of the evidence and puts it out there like a timeline, the timeline, that chart itself is not evidence. That's just a summary of testimony or summary of other evidence. And there are times where judges will even let a demonstrative aid go back to the jury room during deliberations. But more typical than not, the judges say, no, I'm drawing a bright line between evidence that was admitted at trial as evidence, and they can see all of that, 100%, including readbacks of testimony, and anything that was illustrative or demonstrative is really argument. It's not evidence. The times the judges let it go in is when it comes from a witness who actually creates it rather than the lawyer. But if it's a summary or demonstrative aid, the judges are within their discretion to not allow that to go back to the jury room because it technically is not evidence. It's summary of evidence.
It makes sense because they've had to digest all of this information in this case for the past over a week and a half or so. So it's not so easy for them to recall every single detail. But you know, we would all love to be flies on the wall to hear what was going on in that deliberation.
Deliberations are an amazing process. It's collective memory, and you may remember something that I don't, and vice versa. And you get together and you talk about it. And when there's a sort of a little bit of a disagreement or standoff on that memory, that's when they usually send out a note and say, can we see that evidence again, or can we hear that testimony again, so we can put this debate to rest.
Final question for you, because I know we have to let you go. Final question about Luis Toledo. The idea that, okay, he's admitted to killing his wife, but it was self-defense, and that he didn't kill the children, it was Tyshawn Jackson. That's really what he's trying to go for here. Does any of that seem plausible to you?
No, it doesn't seem plausible at all. He's a big enough guy. I can't imagine he'd need to violently strike his wife, unless she had a weapon. I haven't heard that she had a gun or a knife or anything. So his excuse for self-defense doesn't hold water, in my opinion. And more importantly, frankly, is the death of his children. He's in the house. He claims that his friend took an axe and murdered his two children right in front of him, and he couldn't stop him. Doesn't seem plausible. Didn't call the police, didn't do anything about that. I mean, doesn't seem to hold water to me at all.
Especially if this is a guy who took self-defense against his wife, but when it came to the two kids that he was caring for, no, couldn't have done it.
A parent defending their children, if they're trying to save their children's life, will do everything at all costs to save them, including perhaps give their own life for them.
Absolutely. Andrew Maloney, thank you so much for joining us here today on the Law News Network to talk about both Toledo and Willis, and we can't wait to have you back to talk more about it.
Pleasure being here.
Thank
Thanks,
you.
Jesse.
So again,